Hey,
Good morning.
Good morning, Liz.
hey guys.
Good morning. I think it did it again for me and put me as a as a host.
Okay, that's all right. We can take care of that.
Demote me.
We got it.
Thank you.
I'll go back off now.
Hi, Corianne.
Hello.
We're just going to wait a couple minutes to let all the attendees join.
Sounds good.
Okay, I think we'll get started. Welcome back, everyone. Today is day 2 of the 2025 Student Rights Conference, co-hosted by Abdennour Weicker, LLP, and MyPAC, the Michigan Parent Advocate and Attorney Coalition. We had an engaging first day of the conference, which was encouraging. We had 6 total sessions yesterday, and then a Q&A panel of professionals. We are especially glad to see so much engagement by the attendees, so thank you for that. We had an even 100 questions that were asked and answered through the Q&A yesterday, not counting some of the email questions we received for the panelists at the end of the day. There were a few questions for which attendees have reached out after the conference yesterday and asked for clarification, which we have returned emailed, and we will be sure to address in the Q&A as well today so everyone can hear the questions and answers. Thank you very much for your thoughtful engagement. On the first day, we hope to have a similar level of engagement today for day 2. Just a quick review of the logistical items. The conference is intended to be both accessible and interactive. I think we got the interactive part down, and it looks like some participants have used the accessibility features, which is fantastic. The closed captioning option is available for all attendees at the bottom of the screen by clicking the CC link or CC button, which will give you closed captioning options. I mentioned that we'll have a Q&A feature. All of you, or a lot of you, used that yesterday, which was great. We'll use this instead of the chat. The chat will be used for announcements to the attendees, But please do, if you have questions throughout the course of any presentation, drop a question in the Q&A. And just like yesterday, we'll have 2 attorneys assigned for each session to help answer those questions through the course of the session. And if they can't be answered, they'll be given to the presenter at the end of their session. We'll have about 10 minutes at the end of each session, again, just like yesterday's format, for the presenter to answer questions. And then the same thing applies in that 10 minutes at the end of the session. You can put your question in the Q&A. If the question is state specific, this came up a few times yesterday, just make sure to identify the state for which you're asking about. We'll do our best to answer any state specific questions. We do have panelists today from three state area, Pennsylvania, Ohio, and Michigan, and we'll do our best to answer those questions state specific wise. The webinar is being recorded. You probably got a notice of that already. The recordings will be made available to all of the attendees, and that's going to be at the main conference page, which is lawyersforstudents.com/SRC. And we'll hope to make those available within 7 days. We will pause the recording at breaks and at lunch. The slide handouts are available at the same location, the same URL that I just mentioned, and they are broken down by session. We'll have 10-minute breaks at the end of every session, and we'll have you complete a session evaluation, which if you were here yesterday, you know, is a quick evaluation, and that's at the end of every session, not including the Q&A. So you'll have 6 of those to complete right before you leave for the 10-minute break. We'll also give you a link to the attendance verification form, which you can complete at the end of the day. We'll give you that link during the Q&A session, and we'll share the Ohio Supreme Court activity code for this. Just like yesterday, we'll have some poll questions. We'll try to give you a heads up that those questions are coming either through the speaker or one of us panelists. And we just ask that you participate in those poll questions. Sometimes there's not a right answer and you're making a guess, but that's perfectly okay. We're not grading these. So that we will absolutely, just like yesterday, try to stay on track time-wise. And we'll give our speakers a 10-minute warning, which is an indication to wrap it up and take questions, and then we'll cut the speakers off when their time's up. So we want to stay on time, and we just ask that you do too, and return from both the breaks and lunch on time, so our session can begin on time, our sessions. If you have any technical difficulties or logistical questions, please email intake@education-rights.com. You can also call the number that was in the email that you received this morning for day 2. I think that covers it. I think at this point, I will turn it over to my colleague in Bloomfield Hills, Michigan, Corianne Gastel, for a special education case law update. Hi, Corianne.
Hello. Let me just get to sharing. Okay. That look right to everyone?
Looks good.
Okay. Yeah, so as Mark said, my name is Corianne. I am in the Bloomfield Hills office here in Michigan. So I'm part of our small but mighty Michigan team, as we like to say. I guess I'm supposed to give some sort of a fun fact, and you guys can determine if you think this is fun or not. But a fact about me is that I do have 5 children that sort of span the range of needs in school. So I have a child that had an IEP when he first came into our family, and then disqualified for his IEP some years later. I have another child who just got an IEP at the end of last school year. And then I have 3 other kids in a private school and, partially receiving gifted programming. So I sort of definitely have experience across the range, and actually going through these cases is sort of an exciting topic for me, because I think it's important to compare situations to others and see how it's going to pan out in front of a judge, in front of a hearing officer, so that you know the strength of your case, if it's a case against a school, or just the strength of your negotiation standpoint when you're dealing with the school. So I really like going through these cases, and I think it gives good perspective for parents. Yeah, when dealing with your school. So we'll start. We're going to start first with some Sixth Circuit cases. So our seminar, I guess, primarily focuses on Michigan, Ohio, and Pennsylvania, but I did pull in some cases from other circuits in other states. And the reason for that is I think there's a real lack of usable cases, right? There's a few cases that have given us some standards to go by. But as far as, specific circumstances, I mean, think about all the kids that we deal with in the range of accommodations and needs that they have. It's going to be pretty hard to find a case that's already gone to court that, mirrors what you're dealing with. So even when you're, in front of a due process hearing officer, having to file briefs, if you're an attorney or just a parent doing so, I think it's important to pull in cases from other circuits, even though they're not going to be binding. It's going to be helpful and influential information when looking at how other courts handle specific circumstances. So we'll start with cases in the Sixth Circuit. The first one is Doe versus Knox County Board of Education. This was back in the Federal District Court of Tennessee. It went to the Court of Appeals, and then on remand it went back, and I'll explain why. So in this case, this is a 9th grade student who attended a school called the L&N STEM Academy, which was like a type of magnet school. And she has misophonia, which is a heightened autonomic nervous system arousal. So she gets angry, very irritated. She escapes situations when she hears chewing, basically. So, other kids eating and chewing. Her body really goes into fight or flight mode. This is obviously, I see this case as a little bit akin to some of the allergy cases that we might have. It's very similar. So I think this one's relevant, but she missed a lot of her educational time because of this while she was at this STEM academy. Her parents asked for a complete ban on eating and chewing food and gum during academics and extracurriculars. This included her Genius Hour. And so it's a special class that overlapped with general lunch periods. The school didn't have normal or standard lunch periods. That's not the way, it was sort of managed like a college campus. So kids chose their classes. And if they were part of one of these Genius Hours, this hour was a chance for students to take on, specific studies or things that interested them that were not, standard academic classes. So this is one of the classes that was an issue for her. It's notable that out of her 8 classes, 6 of her teachers really did provide a ban on eating in the classroom, but it was up to the teachers whether they did that or not. And that was just the standard all the time, not because of her request. So teachers were allowed to decide. The Genius Hour class did allow food. And part of this is because it was sort of during a normal lunch hour. The school didn't have large cafeterias where they had designated lunch periods. So their argument was, we're required to let students eat during the class. Kids come from all over the state. They drive several, an hour or more to get there sometimes. So sometimes they're at school for 12 hours. We can't really restrict the times that they're eating. Anyway, so they wouldn't agree to no food altogether. They did agree to a gum ban in the classrooms. But not to no food. They said we won't allow classroom parties or big things like that. Parents filed suit eventually and received basically their suit was under 504 and the ADA and some other things, but she wasn't an IEP student. So and it actually didn't even say in this case if she had a 504 plan, but I'm assuming that's what she had. So she filed suit under 504 and the ADA, alleging discrimination, retaliation, and harassment. They also included some 1983 claims for First Amendment retaliation, 14th Amendment equal protection, and 14th Amendment right to bodily integrity. So when this case got back to the district court, it was, primarily to decide on which of these would survive. And on a motion for summary, the only thing that survived was the 504 and ADA reasonable accommodation claims. So the other ones were all dismissed, and you can definitely read the opinion. But, you know, basically none of the other claims survived because in general, there was no adverse action taken against her by the school. They didn't actively retaliate. They weren't actively changing anything about her academics or her educational experience because of her requests. And in fact, they did try to accommodate. They did, you know, they worked with the parents as much as they could. But the case survived on the reasonable accommodation claim. So under 504 and ADA, whether what they provided was a reasonable accommodation and whether they could have provided a more reasonable accommodation. And part of their reasoning was, you know, you may not have normal lunch periods, but there are probably other things that you could have done. They had experts in the case who were saying, you know, you should have standard lunch periods and you should enforce eating times. But the court was like, you could enforce specific eating times. It doesn't have to be in a big lunchroom, but you could enforce eating at specific times. And, you know, we as the court can't make that determination. That's for the jury to decide if whether the accommodation was reasonable or not. So that's how that one turned out. And I do think it was interesting because part of the school's claim was, you know, making any other modifications is going to be a fundamental alteration of our programming. But the court found that there could have been a way probably that they accommodated her that didn't do that. The next case is also from the Sixth Circuit. This is William A. versus Clarksville, Montgomery. And this case involved a student that enrolled in the district in the 5th grade and qualified for an IEP under speech language disability in reading, writing, and math. This is a very interesting one, I think. Maybe they're all interesting, but throughout middle school, so he enrolled in 5th grade, throughout middle school, he tested below the 10th percentile in reading fluency and met none of his fluency goals. By high school, a teacher emailed school administrators stating, I don't think his IEP is helping, and in quotation marks, this kid can't read. He had some technology accommodations that included, you know, things being read aloud to him and helping him write. When you get into the case and read what he was actually doing, I mean, he was, you know, speech to text for, you know, some of his writing. Then he was putting it into like an AI system that would develop an essay out of what he spoke to text. And then he was putting it through Grammarly to fix some of the issues with the writing or with the essay. And he got extended time. So he got an extended 24 hours to turn in assignments. But what the court found is that he was using that time to do all of these things to complete an assignment, which the court ultimately found was not the goal of FAPE, right? FAPE is not just make sure this kid can complete an assignment, but he fundamentally could not read. And part of what got the court to that decision was the parents. So that was, you know, 9th grade or so, one of his teachers thought, you know, he can't read. It wasn't until 11th grade that one of his teachers said, I think he might be dyslexic. So the parents actually requested an evaluation by the school. The school psychologist did an evaluation and they found that he was dyslexic. So the parents immediately enrolled him in some, you know, private services with a dyslexia expert. And she worked with him for, I don't know, some amount of months during the winter of his 11th grade year. And he actually made progress. Like he, you know, jumped from the first level of this program to the second. So she was one of the experts in the case who said, you know, he can make progress if he's getting the right services. And here's why, like we're demonstrating it. So then the parents requested that he have those same services and that his IEP be amended to include those services, and they denied the request. And it's funny when reading, you know, this case or the opinion, there should be like a facepalm emoji, right? Where the court said this, like, this is the most ridiculous rejection that the district made. So the ALJ found that he could not read, but that he could learn to read. It just required something different than what was in his IEP. So the ALJ ordered 888 hours of compensatory education from a trained reading interventionist. The parents actually filed a lawsuit to request, I guess, further clarification that it be from his specialist, so from this dyslexia specialist. And the district then also counterclaimed, seeking reversal of the ALJ's order in the first place. The court agreed with the ALJ, enforced the comp ed order, but didn't speak to whether it should be with this dyslexia expert. So the court seemed to 100% side with the parents and with their experts. It just maybe fell short of requiring that it be with this dyslexia specialist. So I don't actually know after that, this is recent in 2025. I'm at least hoping that the school was like, okay, we should give them that anyway, because continuing with a reading interventionist that is not using, dyslexia programming is going to be useless. So hopefully, fingers crossed, that's what happened. But this was like an easy win, I guess, in court. And another thing to note is that this student did maintain above a 3.0 grade point average, but he was just doing so with, like I said, all those other things he was doing to get work completed. This court actually also cited the Andrew F. standard multiple times, indicating that, his IEP was not reasonably calculated to give him a meaning educational benefit, not just pass his classes. So then I have some Third Circuit cases, and we'll move to these. So the first one is Abigail P versus Old Forge. This is a student, initially it was a 9-year-old student that had epilepsy, autism, global developmental delays, and many other disabilities. Her intellectual, language, and visuospatial functioning placed her below the 0.1 percentile cognitively. So she's similar to a 2 or 3-year-old in all of those areas. So part of what was in her IEP and kind of developed by experts was that she required physical stimuli, being in groups, like being able to touch things, being around people. That was an important part of her IEP. She had a lot of speech language therapy, behavioral therapy, occupational therapy. She would receive, she was receiving hours of it per day in her normal IEP. So this case actually happened during sometime during the COVID pandemic. So this was late 2021. Actually, it was late 2020. Someone in her class had tested positive for COVID. So the district went remote through the month of December. Pennsylvania agency guidelines lifted the, recommendation that they go remote and permitted a return to in-person learning by February 1st. But the district said, well, we're not going to do that because we think there's still really high positivity rates. So they didn't permit in-person return until February 16th, but then they actually added 4 days onto that because they decided they wanted to do a very specific in-depth cleaning process of the buildings. So kids didn't return to school until late February 2021. During that time, the school had actually let the basketball team return to in-person practice by January 4th so that they would remain eligible for district and state playoffs. So during this remote learning, the student received half-hour sessions of her speech language, half hour per day, or maybe it was per week, sessions of her speech language therapy, occupational therapy, physical therapy, behavioral therapy, and adaptive physical ed. So she still received a lot of what she was receiving when she was in person. As far as instruction time, she was receiving an hour and a half per day at home. This gets a little bit muddy because the parents say she didn't receive that. The school says she did. There was an 1.5 hour Zoom sessions where she was receiving one-on-one instruction time. So, and also the mom opted out of some of the occupational therapy to do circle time. The school actually had offered them comp ed because of the time that she was out, but mom said, no, thank you. I've already enrolled her in this summer program to make up for some of the deficiencies. So there was a little bit of dispute between the parents and the school of what she was actually receiving and what she was entitled to. The ALJ denied all of the parents' relief. The ALJ said, the school primarily complied with the IEP, gave, what she was required to have. The court upheld that, and primarily finding that it was relying on the credibility determinations that the hearing officer made. So in that hearing, right, this hearing officer is hearing from the district, they're hearing from the mother. And I guess the mother had repeatedly claimed that she paid for this nurse to be at their home during remote instruction, and the district provided documentation that that wasn't true. So I think that, coupled with, the mom refusing the comp ed time and things, they just found that the district's, what the district provided was maybe more credible, but also went into this, the standard of what is a meaningful educational benefit and what does it have to be. So the court found that the IEP must be appropriate for the student in light of the child's circumstances, which is the Andrew F. standard, and must provide the student the basic floor of opportunity, which does not require the optimal level of services or opportunity, which is something that I think I deal with regularly is, what you want for your child might be the best. The school is not necessarily required to provide the best, but they're supposed to provide what's appropriate in light of the circumstances, and as compared to what other students are getting. So, yeah, so that was kind of the finding. The court found that implementation of the special education and related services must be in conformity with the IEP, which does not require strict adherence to the IEP. So where the IEP lays out what she's getting, as long as they're, generally conforming to that. And just the fact that she normally would have been in school from, 8:30 or whatever it was to 2:30 versus her remote time, which was, half hours here and there, and then an 1.5 hour instruction time. The court said it's very likely that that's the amount of in-person one-on-one that she was receiving anyway, because her school day would have included, breaks for her to implement her strategies on her own, lunchtime, recess, different things like that. So that's an interesting one. I think probably a lot of people had questions about COVID, and some of it seemed to just kind of, disappear after it went away. But this is a case that at least kind of went through that, specific to the facts of this student. So the next case is CB versus Nazareth Area School District. And this case involves a student with autism, apraxia of speech, dyspraxia, mixed expressive language delay, sensory processing disorder, and ADHD. The student received both public and private services to mitigate delays. Private services were primarily speech language therapy, occupational therapy, and behavioral therapy. At first when the student was in the district, he was making progress, but then things began to falter as his behaviors increased. So it sort of increased the restriction of his placement, and the district started saying, we think he needs to be in a more restrictive setting in an autistic support classroom. Parents vehemently resisted this and said they pulled him from the district basically before that could happen. They immediately filed for a due process hearing, claiming that the school's overall approach was flawed, not just that they weren't implementing its IEP, but that their approach was flawed. The hearing officer agreed and awarded compensatory education. Nazareth obviously appealed and asked for dismissal by motion for judgment on the record, which I'm assuming, I'm actually not familiar with it, but it sounds like it's a little bit different in Pennsylvania. They were asking for judgment on the record. the parents were asking for the judgment to be enforced on the record. In kindergarten and grade 1, the student had been receiving itinerant learning support, speech language therapy, occupational therapy. School wanted him in the autistic placement, parents didn't. He continued in gen ed, but the school kept saying, we're going to reconvene to address these behaviors then with an FBA. And actually one of the cruxes of the issue was that the student used an AAC device. And when the student in his private services used this AAC device, his service provider was consistently throughout the day modeling it for him. So always modeling the device, demonstrating how to use it, how to communicate with it. The IEP at the school provided for, services and supports, and for the AAC device. It didn't specifically say modeling of the AAC device. So to me, this is such an important distinction, because when we're drafting IEPs, it's really important what it says. I think the court got it right in this case, because despite this IEP saying that he, was entitled to services and supports, it was more of a general statement for communication support. The court found that the IEP should have said modeling of the AAC device, that was one of the most important things that he should have had. And that was causing the behaviors. It was contributing to his inability to communicate. So the court found that to be one of the most important things. And because the IEP didn't say, and that's where the court differentiated with the ALJ. The court said the IEP should have said modeling of the AAC device, and it didn't, and they didn't implement it because it didn't say it in the IEP. So this was a failure of programming, not just a failure to implement. Because if it was just an analysis of whether the school implemented the IEP, arguably they did. So he's saying, no, this was a failure of programming. The IEP should have said something different, and the school should have been doing something different. And that's because it was demonstrated that he could have made progress, and he could have, communicated better, as he did in his private services, with modeling of the AAC device. So I guess practice tip or parent tip is to be specific in the IEP. And there's other cases that I think I'll touch on after this that discuss that very thing, right? And actually the one that we just discussed, the IEP just needs to be kind of reasonably calculated, and it doesn't require strict adherence. So if there's something specific that you need in the IEP, I think you need to put it in there. The next case is Hempfield School District versus SC. This is a 9-year-old student with autism and speech language impairment who also had a cleft palate. The student had an IEP with specially designed instruction, attended Hempfield in kindergarten, but this one was just replete with staffing issues, which we see all the time in our cases. It's such a big deal. I think Heather touched on this yesterday. It's like the major underfunding for education in general, I think, does have a huge effect on staffing. So this is a special education classroom that this child was in, and the special education teacher and the 4 aides that were in there with 8 students had all training in this behavior methodology in this classroom. The special education teacher went on maternity leave. This was in the kindergarten year. They were not able to find an immediate long-term sub. So one of the special education coaches from the district would fill in. This person said they would fill in 2 to 3 days per week regularly, but the other days were filled in by general substitute teachers. So people that were not trained in the behavior methodology. The school tried to say that during the kindergarten year, the student still made progress because he had the aides there and, things like that, but there was still some regression. So they mixed between this coach stepping in and just regular substitute teachers. And honestly, the record is really muddled about who was there when. Sometimes it was one day, a substitute teacher was there for one day. Sometimes a substitute teacher would repeat several days, but none of them were allowed, per district policy, were allowed to be there for more than 20 days. So that was for the whole kindergarten year. At the end of the kindergarten year, beginning of first grade year, they did hire a replacement teacher. So they got a new special education teacher. But by that time, the aides were having an issue. So special education teacher was there. Two of the most experienced aides that were there quit, and they quit because of the staffing issues. So not only did they not have a special education teacher the year before, but one of the other aides was repeatedly absent. So these two experienced aides were really frustrated with everything. They ended up quitting, and the speech language therapist went on maternity leave. So this student was just, I mean, arguably missing a ton of services and progress on his IEP. So, and actually they did outline in the case, you know, some of the goals, and it was, the school was like, oh, he's making progress, but literally it's, you know, verbatim in there, you know, not making progress, and making progress on one of his goals. So that was the status for the kindergarten, then into half of the first grade year. So the parents ended up pulling the child and moving him to another program in a neighboring public school, but on a tuition basis. So the school, I mean, trying to work through these challenges, had initially paid for part of the tuition and then paid for a little bit more while they were trying to work out their staffing issues. And they offered, I think it was something like, you know, 1 hour per day of comp ed. So when this was appealed to court, the court found that that was not sufficient. The court remanded it, stating that the comp ed needed to be more calculated. It was just sort of an arbitrary number of 1 hour per day that they threw out there. They didn't think that that meant anything. Plus, they provided that there should have been reimbursement for the placement at the other district, even though it wasn't a private school. So even though the parents chose it and it was on a tuition basis, it was a public school. They said there's nothing in the IDEA that requires that it be a private school placement. And that wouldn't make sense anyway. So they awarded them reimbursement at this other placement. Oops, so that's Hempfield. The next one is SM versus Freehold Regional. This one is at the time of the case, the student was 25. And so the initial there is his parents' initial, but the student was, this is covering the 18-19 school year. So when the student was younger, but this is a student that qualified for an IEP under the autism category. He had highly oppositional behaviors at home. And this is like, you could read this case, I keep saying that, but really highly oppositional, violent behaviors that were increasing as time went on. So mom and dad had discontinued his medication in 2013, which they kept noting in the court case, but there was really no explanation for how this was affecting him. The assumption is that it was really negatively affecting him. So his behavioral issues interfered with his attendance at school. So he started on home-based instruction for the 2013-2014 school year. His violent and combative behaviors got worse. He was throwing his clothes away, refusing to get dressed, urinating on the foyer floor where he was sitting, just a lot of crazy things. So this outside company, New Horizons, came in and they were providing the home-based instruction. At that time, they asked that he be placed in a residential facility. The details are really back and forth. So New Horizons then is going to transport him to this residential facility. They help him get ready in the morning before he goes and provides him this transportation benefit or service. And then there's quite a bit of back and forth. So the student had qualified for another residential placement. They moved him into a group home. And then the school said, we actually want him to be in this other school that's similar to where he just was. So for 3 years, he was in this outside placement and actually made pretty good progress. So then after the 3 years, the school wanted him to be in this other, center-based facility. And the parents said, no, we want him back in the district. And they also were asking for services to help him get ready in the morning. So it seems to me like there were probably a lot of claims that could have been brought. The funny thing, the funny thing is that the only claims that the parents brought at court was that he should have had part of his home-based instruction that they failed to provide was that they didn't provide services to help him get ready in the morning. They should have provided new home-based instruction and not be placed in a residential facility. It was just a little bit odd that they only focused on those things. But yeah, the court ultimately sided with the district and said there is evidence that the district did everything that they could and that what they provided him, they didn't have what he needed to be successful, and that he should have been, in a residential placement or in an outside placement. And that there's no way that the IDEA provides that transportation includes services getting ready in the home. This New Horizons place did that, but they're saying that the public district had no obligation to do that. And strangely, they also noted in the case that for whatever reason, the parents pulled him out of the place where he was doing well. He'd made progress for 3 years. Why did they pull him out? And when they pulled him out is when they started having these problems again. So the court sided with the family on this, also indicating that he'd been approved for a residential placement for this other group home. So why would they be pushing the district to provide these other home-based instructions when he couldn't do it? And actually, one of the things they noted was that even 4 adult grown men couldn't get him onto a bus safely. So yeah, that was that case. And the school just kind of rejected. And, reading kind of a summary, you're like, well, then what is the student supposed to do? But he had other options that the parents just didn't want to use. So I'll try to go through these quickly, but the notable cases in other circuits, and as I said, there's not a ton of, cases outlining every specific circumstance. So I think it's important to look at other circuits. I've definitely seen briefs or written briefs where you're pulling cases from other places that have a similar fact pattern. And even some of these that I'm going to go through are similar to specific cases that I've had. So they can be useful if you're in front of a hearing officer or even a court, right? Once it's been appealed, to say, well, here's how this other circuit handled it or how this other place handled it. And sometimes that can be really helpful. So the first one is the McKnight case. So it's SP and AP, or the student is SP, the parents are both AP. So quick summary, this was a 7th grader with autism, had very aggressive behaviors and disruptive mood dysregulation disorder. And the parents requested a private placement reimbursement. The ALJ determined, it's kind of similar to the last one, but the ALJ determined that the district was right in not paying because they had a public building option. So the district is saying, we have an option in one of our public school programs that your child can be in. The facts are, though, that the student had been in public school and doing okay, but as behaviors and aggression increased, they pulled him out and put him into this one treatment program and then into this wilderness program. And he did better there. And so they wanted a residential placement. They wanted a center-based placement when he came back to the district. They wanted a residential placement, not a center-based placement. The district said, no, we have a public, center-based program that you can use. But there was some record that the district had also admitted that they didn't have what was necessary. So like out of one side of their mouth, they're saying we have a public option, but out of the other side, they're saying we don't have what he needs. And so when this was appealed, the court overturned the hearing officer and said, because the district admitted that after these increasing behaviors, they didn't have the appropriate programming, that a private placement was what he needed, and it was what was going to be reasonably calculated to meet his needs. So that's how that one resolved, and he was awarded reimbursement for a private placement. And I have had cases very similar to that, where a district is saying, we don't have what he needs, we think he needs to go here. And then as behaviors and circumstances change, they then say, actually, he can just come to this program. And we're like, what you said before, he didn't have an option here. Why are we fighting a private placement? But as some of the presenters mentioned yesterday, it is like pulling teeth getting private placement reimbursement in Michigan. So that's just what they did. They just said, no, we actually have something here. And that's how it continued, was this fight for private placement, even though they almost admitted that that's what he needed. So, but it, happy for this family that they got the result that he needed, or that student needed. So the next case is out of the Ninth Circuit. So that first case was out of the Maryland District Court. The next case is out of the Ninth Circuit. And these are not published cases either, right? So not only are they not in, they might be from another circuit. Maybe you're in this circuit and it works for you, but they're not published. So, they just could be helpful to you, but not necessarily precedential. So the next case is JB versus Kyrene. And this is a case where a student was restrained several times at the beginning of the school year. The parents then placed him in a private school, and the school paid for part of the year plus more time while discussing how to reevaluate the student. The issue then became, and this is a really key one, I think, is that the parent wanted certain assessments. They said, I want video and audio assessments, not the ones that you're recommending. I'm not signing his re-enrollment forms until you agree to the assessments that I want him to have. School district obviously declined that, and the parents requested an IEE. They then filed a due process claim. So, and I think it's funny that the court mentioned this, but after 9 hearing sessions, the administrative law judge issued a 120-page decision against the parents. And kind of the crux of it was the requests were unreasonable. The district had made multiple attempts to get consent for an assessment, and the parents declined. And then that's basically it. So there was not much more that they could do. After how many attempts does the district really have to keep making in order to get an appropriate evaluation and get the services that your child needs? So it's just really important to be, I guess, aware of the procedures and then reasonable with the district when they're trying to impose them. So if the procedure is that the district does an assessment, and then if you don't agree with it, you request an IEE, and you go through those steps, then that's probably the process you should follow. And if you don't, you could be shooting yourself in the foot going forward to a due process hearing or to a court case, because you didn't let them follow through. If they had followed through, who knows? Maybe they could have come up with a kind of plan that would have been sufficient. And you can't know. So you can't determine if the school did something wrong unless you let them try and then actually do it wrong. So that's, I guess, an important lesson for parents and advocates when dealing with school districts. The next one is GM versus Barnes. This is from the Fourth Circuit. It's a published case, so maybe some more help, a little bit more helpful, and a very important case in my opinion. So this student was not eligible. Well, the school found that the student was not eligible under a speech language disability or specific learning disability because of a pattern of strengths and weaknesses that did not support it. So the testing at the school was what the testing at the school was, even though he had an outside diagnosis of dyslexia and dysgraphia. So this is an important distinction. A lot of parents or a lot of students can get outside diagnoses, but if the school doesn't find that it's affecting the receipt of his education, then he may not qualify despite having those diagnoses. So the parents challenged the lack of qualification, but the ALJ sided with the district, and the court upheld the decision, but also kind of distinguished without making a decision on the matter that the Orton-Gillingham, which is the dyslexia specific reading programming, or one of them, it could be considered specialized instruction. It's just that in this case, it wasn't clear that this student needed it, or that it would be specialized instruction for him. There was not a lot of explanation about why. It's just that in this case, it wasn't entirely clear that he, or that just, I guess, the act of having the Orton-Gillingham instruction automatically qualified you for an IEP because it was specialized instruction, if that makes sense. So they found that the student was still able to have access to the education, to the appropriate education, without it and without an IEP. And their ultimate finding, and I put this in capital letters because I just think it's important, is that his average achievement in school supports this idea that a student does not need special education services if the student is already getting what would qualify as a FAPE without them. And while I, love this idea of a free, appropriate public education, one, I guess, downside to it is the word appropriate. It's almost a subjective term. So who gets to determine what's appropriate? Well, the school district kind of does, right? You can obviously argue with them about it, but I've told parents that if you have an issue with the standards that they're holding your child to or other children to, that might be an issue for the board, right? To revisit the curriculum as a whole. If you want your child held to a higher standard, even your special education child. So if you're in a district where they have a certain level of achievement that they require and your student is reaching that without a special education or specialized instruction, then that's really all that they're entitled to. And that actually kind of begs this next question. I put a note down there. Is that, and I don't know how many of you have noticed this, but in schools, just neurodiversity is becoming more recognized. So there are a lot of students in general education who have different diagnoses, but they don't have an IEP or they don't have a 504, but they're receiving supports in school, like tiered supports. And I think schools are, depending on the district, but maybe doing a better job of providing those different kinds of supports for all students or any student that might need it, which is going to affect this need prong of the IDEA. Does your child actually need it? Well, maybe not if they're receiving what they need just in the general education setting. So I think that's a really interesting thing because parents really, or school districts that are doing a lot of those things well, get a lot of attention, people are moving into those districts, but that is might make it a little bit harder for your student to qualify for special education if they're receiving everything that they need without it or without an IEP or a 504. So those are all the cases that I had to cover. There are more. I think these were just important ones that I wanted to touch base on. I guess takeaways for me, and I don't know if the question popped up, but it's really important to be reasonable with the district. You attract more bees with honey, than vinegar or whatever the saying is. And because when you get to court, you really don't know what's going to happen. You might have a couple of strong cases that help, but if your facts are not analogous, then you don't know what's going to happen in court. You can argue and we can always try, but you're better off if you can to try to resolve things with the district in a reasonable manner. Obviously, there's extreme circumstances where that's not the case, but that's kind of my takeaway, and also to just be reasonable about expectations in the school district, because the school district, only has to provide what they have to provide. They don't have to provide everything and anything, within reason. So that's all I had. I don't know if there's questions. I think this is the.
Yeah, I've got one, Corianne, that we didn't answer in the chat. And the question was basically what was the outcome of Doe v. Knox? Did the court find in support of the student, and what were the remedies or the direction of the court? I think once it was remanded back to the Tennessee District Court is the question.
Right. So it only survived summary disposition, or summary judgment. This wasn't a final trial or something. So I don't know that there was an ultimate out. I don't know that there is one yet. But it survived the motion on the reasonable accommodation. Only on the reasonable accommodation piece.
Right. So at this point, just to summarize for anybody who might not understand it, basically the court hasn't reached a final conclusion yet. Is that
Yes.
right? Okay.
Right. Not as far as I can find, but yeah, that's my understanding. At some point during any case, you can file a motion for the court to make a decision. Basically, we think the facts are so clear that there's no question that has to go to the jury. So you just make a decision. And the court found that on those two, reasonable accommodation under 504 and reasonable accommodation under the ADA, those two pieces of the multiple count complaint survived. The other ones were dismissed on the motion. So those are the only two that will go forward. Maybe they're going to settle it. Maybe it will go to the jury. I don't know. But if I find out, we could definitely, or if something happens, we could definitely distribute that.
Great. And then I wanted to raise something that several people were talking about in the chat and just see if you had any thoughts on it. So one person had said it'll be interesting to see how GM v. Barnes and cases like that are affected by the new dyslexia legislation that's going to be in effect in Michigan. And then there was another comment from an Ohio person saying that she sees this a lot more now with all the dyslexia and reading laws in Ohio. And districts are saying that an IEP isn't needed because the student is getting the science of reading and making progress. So wondering if you have any thoughts on that.
I mean, I definitely have the same question. I think it's going to give a lot more teeth that if, there are requirements in place of when to identify students with dyslexia. I don't know how you get around it. The other thing though is even the last point that I made, if it becomes regular, right? If it becomes a requirement that they identify these students with dyslexia, then maybe they're just given, dyslexia specific training and it doesn't require an IEP. It's just these students are going to be in gen ed. They're going to be in this reading class. These other students are gen ed are going to be in this reading class, and it's not necessarily special education. I mean, I think that's a possibility. And I think it's legislation like this and changes like this that are trying to cause changes in the public system altogether. I guess it depends on your personal opinion, but do we all think that that means every child who's going to get that support needs an IEP? Do we want them to have that? Or do we just want schools in general recognizing that students learn differently? And if they learn differently, let's have different options for learning in a regular general education classroom. It seems to me like that might be preferred. And so does that mean that every child who's recognized as dyslexic get an IEP? Or like I said, let's just kind of change the way we're giving reading education altogether.
Yeah, right.
It'll be
point.
interesting.
Yeah. I don't see any more questions in the chat, so maybe just one more last, if anybody has a question, let's, get it in there. But if not, I think we've answered everything.
There were some very good questions in the Q&A during the course of the session. So I just encourage the attendees, if you haven't looked there, there are some good questions and answers, including, some notable cases over time, in special education that we provided some answers to. So
Can everyone see those questions?
Yeah, they should all be able to see the question. Oh,
Okay.
we've got an open question now. How do we get districts who use SLD criteria as a means to not qualify students who are below the 10%? How do we get districts?
So the question is that we don't want them to qualify students who are below 10?
I'm not sure. How do we get the districts who use SLD criteria as a means to not qualify students who are below the 10%? I'm not sure. Can that person give us a little more
I mean,
to help us answer?
maybe it's supposed to say that they're to stop not qualifying them.
Okay, so it says the student is below 10 and they won't qualify. I mean, I think that's probably a state complaint or a due process issue.
I
I
don't
think
see a way
that's,
around that.
yeah.
Yeah, I mean, definitely there are issues. You can definitely try, right? Like I said, it's always good to try and negotiate with the district, but if they're definitely not doing it, Megan, I think went over this yesterday, and so did Jacqueline, but the state complaint is a good option. You don't have to have an attorney for it. If it's a pretty clear violation, like, listen, he's below 10%, not making progress. I'm sure there's other things in his record that you could use. He needs to qualify. And actually, and this maybe wasn't covered yesterday, but you can file a state complaint. And if you don't get the result that you want, you can still request a due process hearing. So they're both through MDE. You can't do them necessarily at the same time, but you can do a state complaint first, and then you can always request a due process hearing if the state complaint doesn't give you what you need.
Okay, there's some follow-up info.
Yeah, go ahead.
It says this is likely referring to the PSW and strict adherence it requires to districts to find the pattern of weakness. So students will often not qualify under this methodology.
Is that someone else that answered it, or this was just their follow-up?
No, this is a different person answering it. So
yeah, I mean,
possibly.
I definitely would want, I feel like there's probably still a way to make a state complaint if you can pull more information from the record.
Yeah,
But
I would
without
think
seeing
so
it all,
too.
then I don't know.
Yeah, it's hard to know without all the facts. And then another question, has anyone filed a state complaint against the state compliant to OSEP for this student who did qualify if we did file a state complaint? Has anyone filed, I don't understand
Can
the
you read that
question.
again? So
Yeah.
they filed a state complaint because they didn't enforce? Is that what the question is?
It says, I'm not sure. Has anyone filed a state complaint against the state complaint to OSEP for this student who did qualify if we did file a state complaint?
I think this may relate to what you spoke a little bit about yesterday, Liz, in regards to claims against the state itself.
Yeah, that's what I was thinking.
Oh yeah, you can file a state complaint against the state itself. The only entity I know that has had success with that is the Disability Rights Michigan. They did it. The state found against itself. They then filed a lawsuit. And my guess is that they're never going to fight against themselves again, but you could certainly try. But I'm being Debbie Downer again. So, yeah, you can. Yeah, you can file a state complaint against the state itself through the state complaint system. Now, but she's also referencing OSEP, so that makes me wonder if she's actually referencing an OCR complaint. So yes, you can also file a complaint with the U.S. Department of Education with OSEP against MDE if you want to, but then you could also file a complaint with the U.S. Department of Education's Office for Civil Rights against the Michigan Department of Education. I've done that. Several other folks have done that. That's common. There's actually a proceeding. I don't know what's going to happen with it, but there is a proceeding right now that the Department of Education has filed an administrative proceeding against the Michigan Department of Education with respect to how they provided services during COVID. That is just pending right now. We don't know what the outcome of that is, but filing complaints with the U.S. Department of Education against the Michigan Department of Education is also a possibility.
Yeah, and I'm assuming these questions are, what other kinds of complaints can we file so that we're not necessarily going to court? Because most of these cases
Right.
are, due process hearings that were then appealed to the district court and then appealed to the circuit court or whatever the case. So yeah, if there's other options, definitely take those routes if you can. Like if you file with OCR, right, they'll ask, do you have any other pending complaints? So you can't usually have two things going at once. But if you want to take one of the other routes, definitely go for it, especially since you don't know what's going to happen if you get to court.
All right, well, that is all the time that we have for questions, and I think I don't see it. I was going to say one just popped up, but I will. Oh, it was just thanks OCR is very much struggling. If there are any more questions, you can save them for our panel at the end of the day at 4 o'clock. Otherwise, thank you so much, Corianne, for this great presentation. I believe Elizabeth has dropped a link in the chat for an evaluation. We very much value your feedback, and we will be taking a 10-minute break, and we'll be back for our next presentation at 10:10 a.m. Thanks, Corianne.
Thank you all.